Your Honor, my name is Israel Bruce, and I appear on behalf of Mr. William Stiles, who is the applicant in this interim application and the defendant in the main cause of action. My learned friend, Mr. Nazrul, appears on behalf of Prime Products Limited, the respondent in this application and the claimant in the substantive matter. Your Honor, this is an application pursuant to the Civil Procedures Rule 3.9, for relief from sanction imposed by a court order on the 18th of March 2011 pursuant to the CPR Rule 3.13b. Your Honor, the defendant further applies for permission of the court to instruct an expert and to rely on that expert report for the furtherance of this matter. Your Honor, the claimants are and were at all material times manufacturers and suppliers of organic food promotional videos, and the defendant a designer of software systems. Your Honor, are you familiar with the facts of this matter? Your Honor, on November 30, 2009, the defendant and the claimant agreed that the defendant will design and supply to the claimants a software system to be delivered by the defendant in July of 2010. Your Honor, that relationship between the parties broke down to such a level that the defendant could not complete the design of the software and accordingly could not supply the software at the time which was agreed to by the parties. As a result, Your Honor, the claimant issued proceedings against the defendant, and when the defendant failed to file his defense on time, the claimant filed for and obtained default judgment against the defendant on January 18th, 2011. On the 8th of February 2011, Your Honor, the defendant successfully applied to the court to set aside the default judgment. The default judgment having been set aside, Master Chesterfield on the 18th of March 2011 decided to give directions for the matter to move ahead. In those directions, Your Honor, was an order that the defendant, if he wishes to rely on expert evidence in the matter, that he ought to seek the court's permission, and that was to be done by the 23rd of July 2011. Your Honor, there was an attendant to that particular order that should the defendant not apply for permission by the 23rd of July, then he will be debarred from relying on any expert report, expert evidence. Your Honor, the 23rd of July came and went, and the defendant did not apply, and as such he is currently debarred from relying on expert evidence, expert report. Accordingly, Your Honor, the defendant hereby applies to the court for relief from that particular sanction, debarring him of reliance on expert report, expert evidence. Your Honor, this application is being opposed by the claimants. In my submission, Your Honor, I shall rely on the following documents. Could Your Honor confirm that these documents are on the court's file? The amended particulars of claim dated the 21st of July 2011. The amended defense and counterclaim dated 25th of July 2011. The application notice dated the 27th of January 2012. The witness statement of Mr. William Stiles dated the 27th of January 2012 with exhibit WS1, draft expert report, that is, from one Stephen Bannister. Witness statement of Tina Shah dated the 2nd of February 2012. Have Your Honor had an opportunity to read through these reports? These documents, I beg your pardon. Your Honor, the court has a discretion according to the Civil Procedures Rule 3.9, to grant relief from sanctions imposed upon an applicant pursuant to Rules 3.13b. Rule 3.9 requires, Your Honor, that a number of factors be taken into consideration when the court is asked to deliberate on a matter of the sort that is before us. Your Honor, I shall take you through those 9 factors, some of them collectively, others by themselves, and Your Honor, I will make a conclusive point to wrap up my submission. Your Honor, the first question is whether or not granting the relief would be in the interest of the administration of justice. Your Honor, it is our submission that the answer to that is in the affirmative. What is the scenario before us, Your Honor? Your Honor, it was upon the claimant submitting an amended particulars of claim, which reflected a new line of damage in that claim that required the defendant to now make the application that he's making. Your Honor, I'd like to draw your Honor's attention to the amended particulars of claim, paragraph 9D. That's the document of the 21st of July 2011. Your Honor, that paragraph reads, it's the underlined paragraph, Your Honor. The claimant also claims the sum of £120,000 being money payable under the liquidated damages clause contained in the Sunnyfields contract, details of which have been provided to the defendant. The existence of the relevant clause of this contract and the claimant's obligation under it were made known to the defendant at the said meeting at the Wardrobe Hotel on the 30th of November 2009. And Your Honor, if I may draw your attention to the amended defense and counterclaim, paragraph 7 of the 25th of July 2011, Your Honor, where the defendant denies such knowledge. The defendant writes, the defendant specifically denies having been provided with the details of the liquidated damages clause referred to in paragraph 90 of the amended particulars of claim, either on the 30th of November 2009 or at all, and the claimant is put to prove in relation to the same. Your Honor, in addition, the defendant, by his own submission, was seeking to minimize cost in this matter, which hits marks with the ethos of the Civil Procedures Rule. And Your Honor, that is reflected in paragraph 6 of the witness statement of Mr. William Stiles, Your Honor, dated the 27th of July 2012. Your Honor, that paragraph 6, as can be seen from the amended particulars of claim, the additional damages claimed amounted to some $120,000, which constitute a very substantial increase in the claimant's claim. The increased value on the claim completely changes the situation, and I now wish to obtain expert evidence of my own to challenge the reliance that relied upon by the claimant. And Your Honor, if we go back to paragraph 4, which is a paragraph I wanted to bring into focus, it reads, taking this into account, and the pleaded value of the claimant's case, I took a commercial decision not to incur the cost of instructing my own solicitor. I consider this to be throwing good money after bad. Your Honor, has the application been made promptly? It is our submission that in the circumstances of this case, Your Honor, that the application has been made promptly. Your Honor, the statement of case, the amended particulars of claim, was filed on the 21st of July 2011. And this in and of itself, Your Honor, jolted the defendant into some action. But he was further compounded by issues which were beyond his control. And as a result, Your Honor, he was not able to file his application for relief from sanction until January of 2012. And Your Honor, the rationale for that is to be seen in paragraphs 7 and 8 of the witness statement of Mr. Stiles. If I may draw Your Honor's attention to those particular paragraphs I just made mention of. Your Honor, paragraph 7. There are further good reasons why I did not give the litigation the attention it deserved, and did not respond as I should have to the relevant terms of the order. This is the key point. On 6th September 2011, I was sentenced to 7 months imprisonment at the Inner London Crown Court following a conviction for fraudulent trading. And Your Honor, if we move on to paragraph 8, the very last two sentences in the 8th paragraph, I was released from prison on the 7th of December. I went straight to see my solicitors and began to take steps to seek to adduce expert evidence of my own. So Your Honor, you'd see that the defendant was released from prison in December, the month of December, and by January, the defendant would have filed that particular application seeking relief from sanction. Was the failure to comply intentional? And Your Honor, under this particular subhead, I submit that factors C, D, and F could all be adequately addressed by my submission here. Your Honor, the defendant took a conscious decision not to instruct an export in the initial circumstances. And Your Honor, we will be told by the other side that it was a failure on the part of the defendant to comply with a court order. Your Honor, it was not a failure on the part of the defendant. It was a conscious decision that the defendant took not to incur additional costs and not by instructing an export of his own. Your Honor, that I would have referred to in paragraph 4 of the witness statement of Mr. Stiles, and Your Honor, quite naturally, the defendant, having been imprisoned, found himself, or having an imprisonable issue before him, found himself having to give more time to a matter that questioned his liberty as opposed to the other civil matter that was before him. Can the trial date or the likely trial still be met if the relief is granted? Your Honor, it is our submission that there is nothing that is to be had by virtue of allowing this application for relief from sanction that would affect the trial date in any significant way. Your Honor, let it be known, Your Honor, that the defendant has already had a document prepared by an expert, and so where we are in terms of this matter is for the sharing of the matter of the expert report. Your Honor, I have a copy of the report here with me, so that document is ready for the court to deal with. It's a matter of the experts sitting down and trashing out between themselves what they can agree upon and what they don't agree upon, and so that they minimize the number of outstanding issues for the court to address. Your Honor, so it is our submission that in no way would that really affect the trial date or that trial period that is likely. Your Honor, the next question is what effect would it have failing to comply? What effect did failing to comply had on the parties? Your Honor, by failing to comply, quite naturally, the claimant would not have been anticipating this question today, or even thinking of having to instruct the export additionally, which has cost implications to sit down with the export of the defendant. But mind you, Your Honor, we cannot lose sight of the fact that this action today is predicated upon the fact that the claimants amended their particulars of claim to include a new line of damage, which hitherto was not present in the first particulars of claim, and so the defendant had absolutely no option but to take this new course of action. The effect which granting the relief would have on the parties, Your Honor, quite naturally there will be cost implications both for the claimant and for the defendant, but the significant issue that the court must take into consideration here, I submit, Your Honor, it is not so much the cost issue, and we're not minimizing the cost issues as is, Your Honor, but what we're doing is placing the issue of the proper administration of justice front and center as opposed to the issue of cost. Your Honor, the circumstances warrant that the proper administration of justice be given precedence and prevalence over the question of cost as raised by the claimants. Your Honor, the extent to which the parties have, which the defendant has complied with rules, practice, directions, and court orders and relevant reaction protocol. Your Honor, the fact that a default judgment was had against the defendant says that there has been some error or some missteps on the part of the defendant. Having had that default judgment set aside, Your Honor, the defense submits that subsequently there have been entire compliance with the civil procedures rule, orders, court orders, directions, reactions protocol. Your Honor, that is captured in paragraph 3 of the witness statement of Mr. Stiles. Paragraph 3, Your Honor, reads, "After that time, I believe, subject to my comments below, I have complied with all other court orders and directions." And Your Honor, after that time here, the defendant is speaking to after the default judgment, and subject to the comments below, the defendant is speaking to the points made relative to the reason why export was not instructed at an earlier time. Your Honor, the final issue which I wish to raise in this my submission is the question that was raised in Woodhouse and Consignia 2002 of the England and Wales Court of Appeal, the Civil Division at report page 275 of that report, and Your Honor, in particular paragraph 33. If I may draw Your Honor's attention to that particular paragraph. Your Honor, that paragraph reads, the circumstances in which a court may be asked to make a decision of this kind are infinitely varied. This is why the rule instructs the court to consider all the circumstances of the particular case, including the 9 items or the 9 listed items. Your Honor, I have gone through by and large the 9 listed items, and so the final consideration for the court is the overall circumstances of the court. Your Honor, based on the admonitions of Woodhouse and Consignia, I submit that these are the main considerations or the overall circumstances which the court must give attention to. 1. Your Honor, the defendant was granted permission to defend his case after default judgment was had. Secondly, the defense and counterclaim was filed on the basis of the particulars of claim which the defendant did not, for which the defendant did not seek permission to use export evidence or export report. Your Honor, it was after the amended particulars of claim that the defendant recognized the need to know to use an export. And Your Honor, it must be noted that the amended particulars of claim was filed actually some 2 days prior to the expiration of that limitation that the defendant had. Your Honor, the defendant was left absolutely with no choice but to seek the court's permission to use an export and to be relieved of the sanction. Your Honor, conclusively speaking, therefore, it is submitted that based on these arguments that the defendant is asked to be relieved of the sanction and to get permission to instruct an export and to rely on export evidence for the matter before us. Your Honor, this is my submission unless I can be of any further assistance to the court. Thank you.